This is the Hidden Killers Podcast with Tony Brueski.
Featuring defense attorney, Hidden Killers daily contributor, and host of the Defense Diaries podcast, Bob Motta.
This is the examination of the hidden human condition.
You're listening to the Hidden Killers Podcast.
This is the Hidden Killers Podcast with Tony Brueski.
We are talking with defense attorney Bob Motta right now and host of the Defense Diaries podcast. You need to go check that out about the Delphi case and the response that Richard Allen's now former attorneys, through their attorneys, have submitted to the Indiana Supreme Court in response to the Attorney General's response to their initial response to a response to a response. Ultimately, what it comes down to is, was it unlawful, though? That's some of the language that was used in that response on behalf of Rozzi and Baldwin, saying that Gull had an absolute duty to refrain from severing the attorney-client relationship there. I mean, this is something the Supreme Court is going to be ruling on and making a decision on in the coming days, weeks right now.
Yeah, I mean, that's it. If they get to the merits, and that's when I'm kind of, creating that differentiation between the procedural side and the merits. That's the merits argument, which frankly, I hope they get to, because they need to get to it. There's been a lot of back and forth in that case between the attorneys for Gull and the attorneys for Allen, wherein, they're both kind of criticizing one another for not using cases from Indiana in terms of citing cases, because the way that you argue appellate cases is you cite precedent typically. Yeah. And there's two types of precedent. There's persuasive, which is cases that are not from the jurisdiction that you're arguing in, whether it be another court, another state's court, but that it argues the principle that you're trying to put forth to the court, and you'll use it persuasively. And then there's binding precedent, and binding precedent is where, your best case scenario is that you have, a case from that circuit, wherever it may be. That's going to be the most powerful binding precedent on a court, because it's that very court that made that ruling. So, in this particular situation, there's barely any case law on it, because it just doesn't happen. So, both sides have been, like I said, they've both been very critical of the other side for not citing binding precedent, and they've been both using persuasive. And there's this one case, Jones, which the judge used, which is an Indiana case, but it's distinguishable in the sense that in that particular case, the lawyers were removed by the judge. And ultimately, the problem for the judge in terms of using that as her binding precedent is that the lawyers were asking to withdraw from the case, which is obviously distinguishable from this case, because they weren't really
asking.
She's kind of laying on that hope that, okay, well, technically Baldwin requested to withdraw orally, even though, clearly when you read the transcripts, he was. Yeah,
that's not really how that played out. I mean, the only two other situations, and this was cited in there, which the court can remove an attorney, would be if the attorney isn't a member of the state bar, which obviously they are, or there's a conflict of interest. Is there a conflict of interest anywhere in this? Does that conflict of interest come in to where, they had somebody that got in there, took those photos, they spent 17 days, they said, flat out investigating the leak instead of preparing for the murder trial. Is that a conflict of interest, or is that just what Judge Gull was kind of pointing out, saying, look, this is an adequate representation for you. They're trying to get their ducks in a row over here after this all went down. This isn't fair to you. But then again, Baldwin and Rozzi both say, look, this really did not affect the quality of the representation that we're giving him right now. But, it's their words. At the same time, they also did say they took 17 days working on that. So,
yeah. And as far as Gull's concerned, I mean, they didn't really even make a conflict argument, because there isn't one. Had the leak gotten to the point where potentially maybe one or both the attorneys had to testify in court, maybe that creates a conflict. There's a lot of different ways that conflicts arise between either attorneys and or judges with respect to, movements or litigants in cases. And none of those, in my estimation, are here. None of those appear to be the case, especially anything that would rise to the level of removing Alan's counsel of choice. Mm-hmm. I think we say it every week. I mean, you have to try to understand that this case, as it's currently situated, while the overarching theme is to get justice for the girls, Abby and Libby, the reality of the situation is that in this part of the process, it's the defendant's rights that we're concerned with. It's the defendant getting a fair trial, which is all that matters at this point. That is what is key. Yeah. And, and we've talked about it multiple times as well. Ultimately for the girls to get justice, we need them to, have this guy get a fair trial, because otherwise the fact of the matter is this thing's going to get kicked back. And frankly, my opinion on it is that removal, that once Baldwin and Rozzi filed their pro bono appearances, they did become his counsel of choice. They were no longer appointed attorneys. And I think that's an automatic remand. I think that particular situation would theoretically end up with this being a practice trial. Like if these two guys stay on, Scremin and Libredo, and they go through the case and he's convicted, I think it's going to get kicked back because they removed his attorneys, and then you're doing it all over again, which is not what the families of the girls want at all. I mean, certainly, especially if they have more evidence, if they have more evidence against Alan that none of us know about. And there's people out there that think that there's sufficient evidence against Alan based on what they've read in that PCA. I am in complete disagreement with that. I mean, no one's going to change my mind on it. And I'm coming from a place of experience speaking on it. I've tried cases, a lot of them, for a long time. And in my estimation, not going on gut feelings, but going on what's going to be required to prove this case beyond a reasonable doubt, it's lacking, in my opinion. Yeah. Now, does that mean that a jury couldn't come back with a guilty verdict? Absolutely not. They absolutely could. Yeah. Especially when you have cases involving harm that's come to two young girls that resulted in them losing their lives. Juries want somebody to pay for that, which makes it a terrifying proposition for the defendant and the defense attorneys handling that case, especially if they believe, which I believe, that both Baldwin and Rozzi completely and 100% believe that their client's innocent of this. Sure. And that's a scary proposition, knowing that's a possibility, because there's one absolute truth about the law. Well, there's a lot of them, but one of them in particular is that you never know what a jury is going to do, ever. So, because you'll get jurors that are of the same mindset of the folks that think that this PCA is sufficient, that the evidence out there, that the fact that, Alan put himself there at the scene and that they found this unspent casing, that he's the guy, Sure. I mean, that's like, which is, like I said, from a defense attorney side of it, is terrifying. Yeah.
Want to listen ad-free? Want advanced access to all of our interviews before anyone else?
Become a True Crime Today Premium Plus subscriber on Apple Podcasts.
You get every episode commercial-free,
so you can binge on true crime
until you can binge no more.
Search True Crime Today Premium Plus on Apple Podcasts now, or go to our podcast page and sign up now.
More of the Hidden Killers podcast next.